So this portion is going to be talking about contracts. We've already read through the step-by-step guide. We've already read 3 contracts. The contracts we read are the standard tenancy agreement for sale, or I should say purchase and sales agreement from A to B. And then we've read the purchase and sales agreement from B to C. The next one we're going to read is basically a joint venture agreement. Okay, now when is this document used? Let's talk about the documents. Let's figure out when do we utilize them, when do you need to pull it out. So a joint venture agreement is basically you're basically doing a simple partnership. It's simplistic. You have some partnerships where that partnership goes into businesses, but you can also do it for certain types of deals. And this one, typically you're going to be doing deals for, like, there's another wholesaler, another investor, they have a contract, and what you can do is you can do a joint venture agreement with them and help them sell that contract. Because in order for, you can't sell a property unless you have equitable rights towards the property. You have to have a purchase and sales agreement. You have to have some type of right in order for you to sell it. If you don't have any documentation, zero documentation, and you're trying to sell a property, that's representation, that's illegal. You have to have signatures. It's period. If someone else has the signature already on the purchase and sales agreement, what we can do is we can do a joint venture with that person, and now you've just connected yourself to that purchase and sales agreement. That's what this document is. It's also very laxed. It's very flexible. So the agreement that's being made here, it's easy for them. If they find a buyer, they get to collect all the money. It doesn't tie them into sharing money if they find their own buyer. If we find a buyer, what it's doing is it's protecting us that in the event that we find a buyer, that we split 50-50 on that side. Now, so a lot of wholesalers will try and say, yeah, if you bring me a buyer, I'll give you $500. Okay? Your reaction to that is?
I don't work like that.
You are in control at all times. Here's how I work. I'll do a 50-50 split with you, because every single time they're going to try and say that. This is, again, lack of investor knowledge as well. These wholesalers will have a contract or something like that, and they'll say, yeah, if you bring me a buyer, I'll pay you $500. I don't work that way. This is how I work. We'll do a joint venture agreement. We'll split 50-50. If I bring a buyer, we split 50-50. If you bring a buyer, we don't split anything. It's a simple joint venture agreement. We're going to read this so we all understand what it basically says. It's very simple to understand, okay? If you have any questions, just go ahead and stop. All right. But it's a limited partnership joint venture agreement between investor A and investor B. Okay. Investor A, also known as blank. This is also agreement can be signed. Like, let's say you have an investor that wants to help sell the property. You can get them to sign this from you to them, and that also puts in marketing dollars. They're going to put the marketing dollars and put in the marketing efforts. If you find your buyer, you're collecting all the money. If they find a buyer, then you get to split 50-50 profits. So that also helps you sell properties, okay, to also mention. Investor A, also known as, and we'll just call this person, we'll say that we're doing business with them, okay? So we're doing business with them, so that's the investor you're working with. Their name would go there. And their controlled entities, subsequently referred to as IA for investor A. So in the rest of the documents, every single time you see IA, that's talking about the other investor you're doing that partnership with. Have agreed to partner with investor B, also known as, and then your name, company, whoever that is, and their controlled entities, subsequently referred to here as IB, investor B. So every single time you see IB, just keep in your mind, consider that yourself, or vice versa. If you're doing business with somebody else, you have the contract, their name would go there and your name would go up top. Okay. On a transaction involving a wholesale assignment on, and it could say, like on this one, we just need to delete it, but it says on the mobile home, but it'll just say an assignment, a wholesale assignment, property located at, and then the address, subsequently referred to here on as the property, and that's what would go there. And then currently owned by, and then whoever the seller of that property's name goes there, okay? So whoever is in the contract, subsequently referred to here and as the sellers. IA has originated. So again, just reiterate, IA is in this case, since we're using this as the scenario that they already have a contract. So the person that has the contract, that investor, has originated an enforceable contract with the seller and has subsequently solicited you as the investor to assist them in locating an end buyer. Pretty easy language to understand. Under the terms of this limited partnership agreement, subsequently referred to hereon as the agreement. This is just an agreement. IA, and I'll reiterate just a few more times and then we'll stop. That investor that you're doing business with has agreed to share profits created from the sale of the property and exclusively with you in the partnership. Now we're going to stop doing that. IA and IB, so just keep remembering who these people are. IA and IB collectively, subsequently referred to hereon as investors, agree to the following relationship. Definition. IA and IB are engaging in a partnership to facilitate a wholesale assignment, subsequently referred to here as an assignment, between the seller that IA has under contract and whomever the investor can locate collectively as an end buyer. Both parties understand there are risks associated with the strategy and agree to indemnify the other in the event of a lawsuit. What that means is that in the event of a lawsuit, we don't plan on throwing each other under the bus. That's what that means, okay? So no bus throwing is what that means if you want to write something like that down if you're confused, okay? You got notes on the side, you can write on this, that's completely fine. The term of this agreement begins at the time of this agreement is signed and dated until the time the contract closes for the property. Now remember, the moment that you get this agreement signed, they have a contract and that contract's ticking. Okay? Like right now, she just got a joint venture agreement. By the time she got this agreement signed, a week has already passed. Remember how much time we have in a 30-day purchase and sales agreement. You only have really 21 days. So reality is we only have 14 days on this contract. Okay? All right. So you need to get this agreement. The moment that it's signed, that's when this agreement began. Should IA find a buyer before IB and the buyer successfully closes while IA, then this agreement shall be null and void. IB may continue to locate a buyer as a backup in the case the previous buyer fails to close. So meaning that if that investor finds a buyer, they don't owe you anything. Then this agreement is null and void. Okay? In the event that a buyer is unable to close and provide good funds by the closing date, as stated in the contract for the property, and no other backup buyer is available, IB agrees that this limited partnership between the investors is null and void unless both investors agree to initiate a new agreement. Good closing date. Basically, if it closes, this is null and void. The agreement is this agreement is only valid for the property as it listed above. It is not a transferable agreement. So basically, their concern may be that there may have other contracts. It's only agreed upon what was agreed upon, not any other properties. Okay. The agreement will terminate after original purchase and sales agreement expires. Okay, so once that agreement expires, this joint venture agreement expires. It's solely for that purchase and sales agreement. Responsibilities of the investors. The investors should collectively use the earnest efforts to consummate a successful transaction. Individual responsibilities for each investor are as follows. Okay, so now it's talking about the instructions for every person. During the period of this agreement, beginning when the agreement is signed and dated, Investor A will be responsible for conducting the following activities. IA will pre-screen the seller and explain the purchase and sales process. Okay, so that's because they've got under contract, they're the ones that are dealing with the seller. We're not going to be dealing with the seller. That's their responsibility. Okay, that'll make them feel more comfortable too. IA will put the seller under contract, which they already should have. IA will pre-screen the seller to ensure they are willing and able to sell their property. Makes sense. Investor A will pre-screen the seller to ensure the seller is the one on the deed or title. Okay, so they're agreeing that that person is allowed to be selling the property and is on the title. Investor A will also set expectations with the seller. IA will instruct the seller to ready the property for sale, keeping the property clean, keeping the utilities on, safeguarding the home, submit documents needed for the process, and move out prior to the closing date in the contract. Okay, so it's basically instructing the seller. That's what Investor A does. IA cannot guarantee that the seller will complete the above items. So that they're also not guaranteeing to you that they're going to clean out the property. So you're going to probably clean out the property, but it's giving the opportunity for them to do that, okay? In the event that the buyer does not close or is unable to close due to the unforeseen issue on their own part or on the part of the seller, seller will not be reimbursed for any of their expenses by either investor, okay? So the seller will not be reimbursed for any of the expenses that the investors have occurred on that. IA will attempt to locate a qualified buyer and will retain full profit if completed successfully without sharing it with investor B. All right, it's kind of reiterating that they don't, and it's highlighted in this case, saying that you find a buyer, you get to keep all the profits. IA will maintain contact with the seller throughout the process and give them updates. Okay, so that investor is going to be contacting the seller and talking with them. That's their position. IB specific responsibilities include but not limited to the following: work with equal effort to generate a buyer lead and a backup buyer. Okay, so that's what investor B is doing, is finding a buyer. Never portray or present to a buyer manipulated or alternated contract terms or increased or decreased sales price of the property without first consulting with investor A. Now you're just going to be doing a purchase and sales agreement, okay? But the whole thing is that investor A has done a contract with seller, and that does not need to be violated in any manner. So anytime that you're doing this contract, you need to be able to read their contract, because you need to sell something that's not going to be violating what this is stating as well. Now, most investors have they're a little iffy about doing that. That is, again, a sell. That is a relationship that's built. The more that they feel comfortable with you, the better they're going to start exposing all of this. You know, a lot of people don't want to share what they got it on a contract for, but if you're standing your ground and you know what you're talking about, they'll do that. Am I right about that? Okay.
Yes,
any experience there you want to share?
Well, yeah, with the previous gentleman that I found, they had a property in Craigslist, and I went to look at it. He said he had it under contract, and I told him, well, if we can do a joint venture agreement on that. And he said, well, yeah, we can. I said, okay, so what do you have it under contract to see what can we market this property for? He just said that he didn't know, that he will have to check with his partner. So basically, he didn't want to share that information with me. At that point, you actually know that you're not going to be, you might be able to still make business with this person if you continue, but it's going to be a little bit harder. You have to kind of dig a little bit more in order for them to provide you with that information. But it's going to definitely happen.
Yeah, and I mean, just need to be straight up. Hey, in order for me to help, I have to know.
Yeah.
I have to know. I can't do this blindly. Okay, I've been professionally trained. I understand what's going on. This document is protecting you. I need to see that contract, because I can't be selling a contract like I'm going to put money into marketing, because you're going to be putting money into marketing on the investor B side. You're going to be taking these phone calls. You're not going to be wasting time. They think that they can do whatever they want. They can keep marketing the property if they want. That's up to them. But a lot of them don't believe that you're really going to be able to conduct the buyer side, and that's their problem that they believe. So you need to ensure, hey, this is I'm taking this very seriously, but in order for me to help, I have to have this information. Okay. Identify and pre-screen the buyer. So that's what you're going to be doing, is basically making sure that they have money, they're ready to close on this transaction. Investor B will allow IA to maintain sole communication with the seller and agrees to refrain from contacting with the seller. So that'll give comfort to IA, as if we're the ones that's under contract and we're dealing with investor B, we want to make sure that investor B does this, that they're not contacting the seller. We're maintaining the conversation with the seller at all times. Okay. Orchestrate a meeting with the buyer and IA to sign all necessary documents and obtain a deposit. Okay. Okay. I mean, sure. I mean, if I've got a buyer, we're going to make them sign make them sign the purchase and sales agreement and all that. Okay. But basically, what that's stating is that you'll get the signature from the new buyer, and you'll let the investor A sign and get all the sign for you on that purchase and sales agreement. That you're just going to help them facilitate that. If you've got a buyer and then everyone's cool, you shouldn't have to worry about that. In the event that IB brings a buyer, it is up to IA to accept the final price of sale. Okay, so you need to be in contact with them about marketing it for sale. That's who you're talking to, making sure, okay, have you lowered the price? If they've lowered the price, you need to be lowering the price. You don't need to be the most expensive out there while they're at a cheaper price. But another thing is like, hey, when I'm going to be marketing this property, at what point do you want me to call you for, if I've got an offer, what do you want me, at what point what's the lowest offer I'm allowed to accept without calling you, things of that nature. If you do get an offer that's a little bit lower, contact them, say, hey, we've got an offer at this price. This is their max offer. What do you want to do? No, we can't accept it. Okay, no, we can't accept it. Yes, go ahead and accept it. Good. At least that communication's happening there. In the event that the buyer does not close or is unable to close due to an unforeseen issue on their own part or on the part of the seller, buyer will not be reimbursed for any of their expenses by either investor. Okay, so if there's any issues, that's what that is explaining. Profit sharing. The profit from this transaction shall be in the form of an assignment or facilitation fee that will be generated on the HUD. So the HUD statement will say assignment fee, it'll say facilitation fee. I've always seen it say assignment fee. Whatever it states on that assignment fee, okay, that's what we're talking about here. Another type of profit may be generated if IA closes on the property and then resells it to IB's buyer. It's calling it a dual close, same day close. That's a double close. We've already talked about that. In that case, profit will be calculated as net proceeds resulting from the difference between the purchase cost after expenses and in buyer sales net revenue after expenses and any assignment fee profit collected. Investors agree to the following after expense profit split of investor A at 50% net profits, investor B 50% of net profits. Profit sharing, again, only happens in the event that IB produces the buyer and IA agrees to the price. Okay, so that's only when you bring or IB brings the buyer, that's when the profit's shared. Expense sharing. Expenses can be incurred as a transaction through various activities, including performing repairs, cleaning, maintenance, paying for utilities or to have utilities turned on, inspections, etc. In all cases, expenses over $25 should be discussed and agreed to in writing by investors prior to the commitment to spend the money. Any agreement must be attached an addendum to this agreement. Typically, you don't even put in the expenses. Typically. But if you wanted to, it has to be agreed upon ahead of time that, okay, I spent $75 on this, so you can get reimbursed that for the money that you've spent. But if you're going to be making $2,000 to $3,000, no need to nickel and dime. You know what I'm saying? But it has the ability that if you want to get that accepted, you can, but it has to be accepted ahead of time. In all cases, expenses should be separately recorded by each investor in each transaction. At the conclusion of any of the scenarios listed above, all expenses will be divided and paid equally among all the investors. Ethics agreement. Both investors shall take the matter of ethics very seriously. IA agrees to no liability for illegal or unethical practices of IB, and IB accepts no liability for illegal or unethical practices of IA, which is basically saying that if IA is doing something illegal, IB's not. They're not connected. If IB does something, IA is not connected at all. They're responsible for each other. IA and IB collectively identify and hold harmless each other from actions determined to be illegal or unethical, meaning that you're not responsible for what they do and they're not responsible for what you do. You guys are your own individual parties here. Assignment fee opportunities pursued by the parties of this agreement will abide by all known laws that govern such transactions. IB promises to respect IA's position in the deal with the seller. Additionally, parties to this agreement agree to treat sellers and buyers with respect and to honor any agreements to commitments made to sellers and or buyers. Makes complete sense. Okay, it's easy to understand. Additional provisions. So extra things. Both parties understand there are risks associated with this strategy and agree to identify the other in the event of a lawsuit. It's already been reiterated, said 3 times. Basically, you're not throwing anybody under the bus. Investors shall identify and hold assigners harmless from any other claims, damages, expenses, and liabilities, whatever nature, including attorney's fees arising from the contract or related to the property or resulting from the assumption of assignee of said contract after the date hereof. Okay, basically no bus throwing. You're holding them harmless, they're holding you harmless. In the event that the parties to this agreement die or are disabled during the term of this agreement, the remaining parties and the state for the deceased or disabled will make all decisions for the deceased or the disabled, and the deceased person estate will receive the profit share from each completed transaction. Okay, so if there is a contract, you're about to make $50,000, your estate will get to handle all that, but they're agreeing that they still will pay, and your family will take care of that. In the event of a disagreement between both parties regarding items not covered by this agreement, parties will agree to mediation before initiating any other legal options, meaning before you go to court, they're going to go through mediation first. Any dispute related to this agreement, which is not resolved through informal discussion, will be submitted to a mutually accepted mediation service. The parties to this assignment shall bear the cost equally. Okay, so the mediation company will say, hey, they'll read this document, and they'll say, hey, here's what's going to happen, and they'll take care of it. If any legal proceedings are brought forth, the prevailing, the one that wins, party shall be entitled to recover reasonable attorney fees and all costs of such proceedings from the other party. The assignment shall be binding upon and shall inure to the benefit of the parties and their respective heirs, legal representatives, successors, and assignees. Okay, so this is talking about in the event of a death. Okay. In case any one or more of the provisions contained in the agreement shall for any reason be held to be invalid, illegal, or unenforceable in any respect, such invalidity, illegality, or unenforceability shall not affect any other provision thereof, and this agreement shall be constructed as if such invalid, illegal, or unenforceable provision had never been contained herein. So basically what that's saying is that there's one of these little dots, one of these little bullet points, one of these provisions in this document, if one of those is illegal, that doesn't make the entire document illegal. It just makes that one provision just basically null and void. That's all it's stating. Everything else is still in contact, because that's what an attorney will do. An attorney is going to find one little thing wrong with the contract and say that the entire contract is invalid because of that one little provision. This is stating that that provision is wiped out, but the rest of the provisions are still intact. This agreement constitutes as the sole and only agreement of the parties hereto, and supersedes any prior understanding or written or oral agreements between the parties respecting the within subject matter. Meaning that if there was something agreed upon, it needs to be written in here. If it's not written in here, then it doesn't exist. That's what that states. In the event that any parties becomes insolvent, disabled, or are not able to fulfill their obligations in this agreement, the other parties should first attempt to negotiate a resolution and then agree to mediation before other legal options. Okay, so basically we're communicating first before we deal with anything, trying to make everyone feel comfortable here. In the event that any party becomes divorced during the term of this agreement, the agreement remains intact with the original parties and will not transfer to former spouses. So divorces, they're not attached. Okay. IB will be paid at closing or after final transaction, and or the HUD shall reflect marketing fee, whatever, assignment fee to IB from the proceeds made after expenses. This agreement shall be interpreted under the accordance of the laws of the state of, and then whatever state it is, and this one is, we just change it out. Signatures below represent a full understanding of the partnership agreement, a full understanding of the wholesale assignment process and its risks, as well as agreement to all of the above terms and conditions as the date written below. And then investor A signs, and then investor B signs, and now you have a document that is signed. You now have a contract. Now you can start marketing the property. You can't market it ahead of time. So now you know what that contract sounds like. You know what it says, and you're good to go there. So the next document we're looking at is not necessarily a purchase and sales agreement. It's just a letter of intent. It's real easy to understand, but now that we're starting to learn about JV agreements, we're starting to learn about these purchase and sales agreements, when you're talking to your seller, there's ways that you can make offers and give multiple options to them, where one offer can be cash, the other one can be an owner financing offer, or another owner financing offer. So what this document is that you're looking right here is just a very good way of writing that offer in there and giving it to them. Now, if they accept the purchase, getting any kind of signature is always good, but this really doesn't have a lot of validity to it either. Okay, but it is a very nice document just to be able to just say, hey, here are my offers to you, and then you write out the offers, just keeping yourself a little more professional on this side. It's nothing real crazy, but I'd just like to give something to somebody on, if I'm making multiple offers. And then it gives you the ability to also scan that in. And then if they say no to that offer now, you can always follow up and what offers you've already given them as well. Okay. Any kind of documentation is a good documentation. So I would what I'm giving you here is everything that you're going to need to have printed off, like your main contracts that you really need to understand. You have other contracts as well, and a lot of contracts, but we don't need to go into them because you don't utilize them as much. But at least you understand, you've got to read the documents. You're reading the documents. After you read it and it makes sense, you start understanding what that document is for, and you can understand how to execute that document. Okay, so let's next. All right, this authorization to release information. Anytime you're dealing with anything on the loan, in order for you to talk to the bank, you need to have this authorization to release information signed, so you can even talk to the bank. The bank will not talk to you individually. So, when would you talk to a bank? If let's say they're behind on payments, they're in pre-foreclosure, and you need to talk and discuss with the bank about their loan, whether we need to start, because we don't know if we're going to be doing a short sale, meaning shorting the note, talking with the bank about taking a discount on that note. You got to have the authorization to even do that. If we're going to be taking over the payments of the house, we need authorization to release information, because they may not have all the documents we need to talk to the bank. We need that authorization from the bank. So anytime that we're going to be dealing with the loan, we're going to be touching the loan. Now, if we're paying off the loan, it's a different story. But if you're going to be involved with the loan in any kind of seller financing or something like that, you need this document signed. So have it in your file of paperwork. And you're like, okay, I'm getting the purchase and sales agreement. Wait a minute, I also need to get an authorization to release information. And then you pull this document out as well. So if you want to write notes about that, you can. It's a simple document. They got to put their social security number. You can also get this done later too, by the way. So if you forget the purchase and sales agreement, you got the purchase and sales agreement, but you forgot to do this, purchase and sales agreement is the main kit and caboodle. You need to get that signed. You can always come back and get this signed. However, it is going to be a step that you're going to need. But if you don't know that you need it, don't worry about getting it signed right then and there. Don't need to. You can always go back. Okay? But understand what this document allows you to do is just release the information from the bank. Okay?
You said you need their social security number for this?
Yeah, if you look on the second page.
Oh, sorry.
Because the bank is going to make you fax all this into them.
Got it.
So if you fax this in, they're going to want to see that they've signed, what the loan number is, who has authorization, what property address. They want it to be very, very specific, and they also want to see the social security number with it. And then from there, you're good to go. Another thing that you can also do is you can get the person to call the bank and give them a verbal authorization to release information. They'll put it on file, but they're still going to want to see this document. Okay? But having a verbal authorization is not bad either. Okay? Next. Now, this document is a very good document to have. What this is a notice of contract for the purchase and sales agreement. This is basically talking about the seller here. The seller and you. So let's just talk A to B contract, the purchase and sales agreement. They back out of the contract. That purchase and sales agreement with the signatures that you have, in our courthouse, our courts, you should be able to, in any court system, you should be able to take that purchase and sales agreement, go to the courthouse, give it to the clerks, and they record it against the property. Okay, so there's documentation. It's recorded at the courthouse so that anybody looks up the deed they see that you have a claim towards the property. Okay? In some courthouses, you have an issue doing that. They don't want to record it. The reason is because it's not notarized. You should be able to just do that. Okay? So if the seller decides that they're backing out and they're not selling the property, you need to be able to have a notarized document saying that they've went into a contract with you. This one right here is a bilateral agreement that allows you to notarize, and it's basically saying that there is a contract on this property, but you've got to get them to notarize. The problem with this contract is the chances of you getting them to sign it are pretty slim, okay? Because if they're backing out of the contract, why are they going to sign a contract, get it notarized so you can go record it against the title? Make sense?
Yeah, they're not going to.
They're not going to. In some cases, like where we have like maybe a title issue, like there might be a title issue, but you want to record it, but the sellers recognize that there's a title issue and you're not closing right then and there, you might be able to get it signed under those circumstances. Okay? You're just basically saying, hey, we're just waiting out our time. We need to get this bilateral agreement signed, get it notarized. That way you can record it against the property. That's when you'd be able to probably get it signed. But if the seller is just backing out of the deal, chances are you're not going to get them to sign this document. However, if you're able to get this document signed, it's gold. Okay? If you can't get them to sign it, okay, so you'll see here that it's a bilateral, meaning that the seller is signing and even the buyer is signing, and that's getting notarized. Makes sense, right? And that allows you to grab your purchase and sales agreement. You then grab these contracts. You then go to the courthouse and you say, hey, I want to record this against the property. They look at the signatures, they look at the notary, and they say, good to go, and then they put it against the property. Makes sense, right? So you might be able to, in certain circumstances, get them to sign this, but if the seller is just backing out just because they don't want to sell, they're not going to sign this document. Under certain circumstances with like the title, possibly, okay? So you have this just in case.
Okay. Now, what happens in the instance that your seller doesn't live close to you?
Okay, so that's the next document. Okay, so, but if they're willing to sign it, you can get it notarized, get it shipped back, then you get the signature, get it notarized.
No, but I thought with a notary, okay,
Uh-huh.
the parties have to be present in order for them
Oh,
to
both
notarize.
Good question. Good. Then you would go to the next document. That's
Okay.
going to be the next document. So that one is a bilateral agreement. Bilateral agreement means what?
Two parties.
Two parties come together. This one is a unilateral agreement. Unilateral agreement means that one party is available.
Mhm.
Okay? That's what this document allows you to do. A lot of courthouses, they want to see that there's a notary.
Mhm.
What this document is basically the same thing as the last document, only it's unilateral. It doesn't say anything. You don't want to say anything at the courthouse either. What you're doing is you fill this out yourself. Okay? You then go get this notarized. Boom. Then you grab your purchase and sales agreement. You put it underneath this document. Then you go to the courthouse and you say, I want to record this against the property. They will then look at this. They will see that it has been notarized. They see the purchase and sales agreement, and that's how you get around it, is with a unilateral agreement.
Mm-hmm.
This is how you record it, is with this guy right here.
Right. Okay.
Cool?
Yeah.
Pretty simple, right? So most of the times, this is what you're going to have to utilize to do to record it against the deed. If you have a seller that you feel is being iffy, you got yourself a good deal. Now, this isn't a deal that you believe it is a good deal, a very good deal, and then your seller is starting to be a little wishy-washy. Now, if it's a wishy-washy deal, you think you're going to get out of the purchase and sales agreement in the first place, you don't need to do this. But if it's a really good deal and now your seller's starting to back out, they're starting to have issues and all that, go ahead and record. You're going to get a unilateral agreement. You're going to notarize it. You're going to get the purchase and sales agreement. You're going to then go to the courthouse. and you're going to record your interest on that property, because that's the only way that you're going to be able to like show that you have an interest in the property at that point in period of time. This is a very, very powerful document that you have right here. A lot of people don't know anything about this document. This is the document you really need. Right here is the unilateral agreement, right here. And just get it notarized. Just takes you a second. Cool, right? Okay, so the next one we're talking about is going to be a trust agreement, trust document. This is a very, very powerful document to understand and know. Now, you utilize this if you're going to be holding real estate, if you're going to be taking over real estate. You can utilize it in certain circumstances to do certain wholesale transactions as well. Like if you're dealing with an REO property, there might be the chance that you're dealing with an REO property and they want you to like hold title for like 3 months before you sell the property. You can utilize a trust. A trust there's a lot of things that can be done with a trust. The laws change once things go into trusts. Laws change. For an example, if let's say somebody comes up to me and says, "Hey, Brandon, will you manage my property for me?" I don't have a license to manage anybody's property. I don't own that property. There's nothing I can do there. In order for you to manage property, you have to have ownership in the property. Okay? If I don't own it and I'm managing their property, I'm basically representing them. I don't have a license. That's illegal. However, I can put myself, and this doesn't make any sense right now, but it will, I can put myself as the trustee of a trust, which is basically the manager of a trust. That's what the trustee is. We'll talk about each position in just a second. And we can have the trust own the property, and as the trustee, I can manage the property legally. It changes the laws once things are in trust. Trusts are very, very, very powerful documents, okay? So understand that the trust owns everything. It owns the real estate. It can own cars. It can own art. It can own guns. The trust owns those things, not a person. This document owns those things, all right? The beneficiaries and the trustees hold this document, and they hold it secret as well. So what gets recorded is basically that there's a trust that owns the property. That's all it says. And whatever you name the trust. So the name of the trust is the owner of the property, not a person. There are people involved in this trust that are basically managing the trust within and taking care of what's involved in that trust. Now, here are the people that are going to be involved in the trust. You have a grantor, okay? A grantor, and on this one it says /settler. These people, whoever this is the one that created the trust. Okay? You have a trustee. A trustee, think of them as a manager, okay, / like an employee. Okay? You also have a beneficiary as well, or beneficiaries. Obviously, singular to plural. A beneficiary, we'll just call it beneficiaries because I don't know how to spell real well, so we'll just go beneficiaries because it's the first word I see. Beneficiaries. Think of them as the owner of the trust. So in this relationship, you have a trustee that answers to the beneficiaries. The trustee is managing the trust. Okay? The beneficiaries is the owner, and the owners, the beneficiaries, are giving the trustee certain obligations and duties. And then you have successors. I'm gonna attempt to spell successors. Help me out here, okay? SUCCE SO.
SS, I think. ORS. What were you
OR.
gonna say?
That's correct.
Okay. Successors are going to be in the event that people pass away. Who's taking place? Who's taking position? Position is POIS.
ITION.
IT.
ITION.
Position. Who's taking position in the event that someone passes away? So who are the successors? The verbiage in a trust are going to be like this because we're literally adopting a verbiage and a language from a Greek Roman time period, and we still utilize this document today. Back in the day, they had these scrolls that they would use. History, real quickly on the trust, is that the history of it was what would happen is that you'd have a landlord to a property. You'll notice that a lot of our language is adopted from like Greek time. And then you'd had back then a landlord. And a landlord at that time is a much different landlord than it is today. The landlords back then literally controlled like the entire land. And within that land, you would be a tenant and you would contribute to the land. And then you would get the title of like a blacksmith, and that's what you would do. And then you would get the title of whatever, you would herd sheep or whatever, and then you would be a farmer or something like that. And that's where we got our last names and everything else on that side. And what would happen is that the landlord, because they would have to fight for the king, they were fighting for their kingdom, they would go to war. The landlords would. Well, the landlord, at that time, they would appoint someone to manage the land. And they would quit claim their rights over to that person. And they would say, hey, Patrick, I'm going to go fight for the war, but I need someone that I trust that can go and manage the land while I'm at war. So I'm going to quit claim my rights over to you, Patrick. You will manage this land. You will take care of this. If I pass away, that's yours. You've earned the right. But if I come back, you'll give it back to me because I'm fighting for our kingdom. Okay? That's what would happen. The person then would come back and they'd say, I survived, Patrick. Thank you so much. Well, right now, because I'm the landlord, beforehand, that meant that the lineage, because I was the landlord, my bloodline would always be gifted the land, and they would always fit into the position of being the landlord. Well, now I've quit my rights and gave it to Patrick. Okay? Patrick's about to become back to being over some kind of like blacksmith or something like that. Do you think Patrick wants to give me back the land now?
It kills you.
He says, no, I'm not giving it back. And then I'm sitting there saying, wait a minute, why aren't you giving me back this land? Well, now Patrick's lineage gets to be the landlord. So then they started petitioning to the king. And the king started saying, wait a minute, there's nothing we can do about it. The laws of the land are this. This is what the laws of the land are. You quit your rights over to Patrick. Patrick now has the rights to this property. There's nothing that you can do. Patrick is the sole decision maker at this point. So then they created what was called trusts. And they had these scrolls. And they would basically say this. Let's quit our rights into this trust document. I will remain the beneficiaries while I'm over into war. If I pass away, I want my lineage to still be protected. I still want them to be taken care of. So then they would be appointed in the position that I pass away. The successors would just take over and be put into. They would become the beneficiaries. But I need someone that I can trust that can manage all of this while I'm away. So then what I can do is I can appoint somebody, the trustee, to manage within that trust what happens. So you get to be basically the landlord, but all you are is really the trustee. In the event that I pass away, the trustee takes care of the position for the successors. They manage the land. I come back, and what I can do is I can fire a new trustee if I choose necessary. I can sit back and decide I don't want to do anything and let him manage the land if I want to. But he basically works for me within that trust. So then they created this trust document, in order to do that. It's the trust that owns the property, okay? Because that got created that way, trusts are used a lot for like estate planning purposes, okay? Because here's what ends up happening. If I own the property, it's in my name, and I decease, I pass away. Well, right now, let's say I don't have a will. So then they have to go to court. Everyone's fighting for my assets at this point, okay? And they basically say, then they have what's called common law, and a judge then has to appoint who owns, who is going to get the estate, who is going to get my property at this point. But that means that the heirs, that means the people that are involved have to pay for attorney's costs. They have to pay for estate planning, taxes, all that kind of stuff. There's fees that are involved in that. Even if there is a will, this still has to face a judge. A judge reads that. They look at assets. They look at debts. Sometimes they say that in order for the heirs, sure, let's say I have children, and my will says that my children's going to get this house. Okay? So this is another thing that we're talking with probate. So let's say that the will says that the children are going to get my house when I pass away. Well, when a judge reads that, there's going to be, let's say that before I passed away, I racked up a bunch of credit card debt or medical bills. The judge is going to tell the children, in order for me to release any of these assets, you have to pay off the liabilities before you do that. Okay? So then it sits in probate, but it still costs money. So regardless of whether there's a will or no will, it has to go through probate. But because the property, the deed is owned by a trust, the trust is still alive. The people in the trust can pass away, but the trust stays alive no matter what. So it passes probate. It never has to go through probate. It never goes through probate once it's owned by a trust. The trustee would just then appoint another beneficiary, and that beneficiary is taking over what's inside of the trust. But the trust still owns the property. It fits under a whole new set of laws that we still adopt to this date that was given to us centuries ago because of what they were doing in war and all that kind of stuff. And we can utilize it for estate planning. You can utilize it to take over payments. This is the document you have to understand. This changes rules completely. So understanding trust puts you in another level. It is a very, very, very good skill to have. People will ask you a lot of questions about trust. If you know about trust, you are an expert in the real estate world. And we're about to read this trust document, and all they need to do is just read the document and it'll make complete sense. So let's go ahead and read this. We can ask questions, we can do the research, and we can completely, fully understand what's going on here. Okay? So, the agreement and declaration of trust is made and entered on the date, whatever the date is. Now, this trust document will be notarized, okay? That's what makes it a legal trust document. We can create a trust today and get it notarized, and you can have it sitting there ready for you to purchase things. We should probably end up doing that, actually, but... Okay, so blank is the grantor, settlers, and beneficiaries, okay? So looking at the ownership there, hereon collectively referred to as beneficiaries. So the owners, basically. Whose address is, and then the address. And blank as the trustee of the trust, the manager. Now the trustee can be fired by the beneficiaries. Always remember that. Because we're going to talk about that a little bit later. Okay? Hereon referred as a trustee, which is designated, shall include successor trustees, whose address is, and then the address of the trustee. Whereas the beneficiaries are about to convey or cause to be conveyed in the near future certain real property to the trust, meaning they're going to put something into this trust, to the trustee. And the trustee has agreed to accept such conveyance and hold the real property as fiduciary in trust for the beneficiaries under the terms and conditions set forth below, meaning that the trustee is taking responsibilities for the trust, okay, for the owners under the terms and conditions set forth below. That's what that means. The trustee is taking the responsibilities for the beneficiaries. Now, therefore, the parties hereby agree as follows, declaration of trust. The trust created by the settlers herein shall be known as the blank, hereafter referred to as the trust. That's the name of the trust. What are you naming this trust? Typically, a lot of people name it the name of the property address. So they'll go like 123 Main Street Land Trust. They'll name it, and there's always controversy on what you should actually name your trust. You can name it anything you really want to, okay? A lot of people just name it the property address, 123 Main Street Land Trust. It needs to say Land Trust at the very end, okay? So whatever you name it, Land Trust. But you can name it Scooby-Doo Land Trust. You can name it anything you want, Land Trust. It won't matter. You can name it whatever you choose you want to name this trust. Trust property. The corpse of this trust will be real property, so the body of this trust will be real estate. Hereinafter referred to as the trust property. So anytime you see trust property, that's talking about the real property. Because now it's changed actual real legal definition. It's really not real estate at this point. It now turns into a real estate asset. I mean, a personal asset. A personal asset, like your cell phone is a personal asset. This is a personal asset. Real estate is not a personal asset. It is a real estate asset. The moment it goes into a trust, it turns it into a personal asset. Okay? Because it's the trust. The trust is a personal asset, so it changes the laws into personal asset at that point. From what I understand, let me add that in there. From what I understand on law on this. And I'm not an attorney, but we've read this many times, and I've done this many times. That the beneficiaries will convey or cause to be conveyed fee simply absolute by deed. Okay, convey or cause by conveyed fee simply absolute by the deed. I guess it's talking about the beneficiaries will convey or cause to convey fee simply as absolute by the deed. So the beneficiaries are, I guess, are paying for the fee to absolute by deed. Some of these are literally still the same verbiage as it is in Roman time period. Said property is described in an attached Exhibit A. Okay, so the property that's in this is going to be in Exhibit A. So let's go to Exhibit A. It's going to be at the back of this. Right there. Keep going. Keep going. Right there is Exhibit A, and that's where the property address is going to go. Okay? So when it's talking about Exhibit A, that's where it's talking. The trustee, which is the manager, shall hold full legal and equitable title to said property in trust, only for the use and purpose stated under the terms of this agreement, which we'll explain later, and any valid addendum hereto duly executed by the parties. So from the beneficiary to the trustee, what is agreed upon, anything past this point, this is the responsibilities of the trustee, and it'll be explained later. If permissible in the state in which the real property sits, title shall be held in the name of the trust itself. That was in number 1. Okay? So the name on title will be what is in number 1. That is the name of the trust. That's who's going to hold title, is what's the name of the trust. Otherwise, the trustee shall hold title in his or her name as individually as a trustee and not personally of the blank land trust, whatever that land trust is named. Okay? Trust purpose. The objects and purpose of this trust shall be to hold full legal and equitable title to the trust property until its sale, disposition, or liquidation, which means sale, or until the trust is terminated or expires by its own terms and/or as matters of law. Okay? Does that make sense? Okay. The trustee shall not undertake any activity that is not strictly necessary to the achievement of the foregoing objects and purposes. Nor shall the trustee transact business within the meaning of the applicable state law or any other law, nor shall this agreement be deemed to be or create or evidence the existence of a corporation. This is not a corporation, basically, de facto or de jure, or a Massachusetts trust, or any other type of business trust, or any association in the nature of a corporation, or a partnership, or a joint venture, or a limited liability company, or a similar limited liability associated between the trustee and the beneficiaries, or between the beneficiaries, meaning it is not a corporation. This isn't a limited liability company. This is a land trust. That's what that means. All right, so what it's basically saying is that you have laws when it pertains to businesses and corporations. You have laws when it's based upon human beings like ourselves. You have laws when it comes to trusts. We are not talking about the laws. We're not talking about anything here. We are talking only the laws that govern based on a trust. That's what that's possibly talking about. That's basically what that's talking about right there. Next page. Consideration. The trustee has paid no consideration for the conveyance of real property described here, and they haven't paid anything. The trustee hasn't. The conveyance will be accepted and held by the trustee, subject to all existing liens, encumbrances, easements, restrictions, or other clouds or claims against the title thereto, whether the same are or of record or otherwise. The property will be held in the trust, terms and conditions, and for the purposes hereinafter set forth until the whole of the trust estate is conveyed free of this trust as hereinafter provided. What this is basically saying is that the trustee, the title may have liens, it may have encumbrances, there might be issues with the title of this property. The trustee is saying we're accepting it. We're going to accept whatever it is that's going on within this house. Whatever's on the title, whatever's transferring over, liens, encumbrances, issues, nothing. If there's nothing wrong with it, the trustee is accepting that. That's what they're doing. They're accepting to take care of those issues. And they can sell it if we can sell it later with free of those encumbrances. We can do whatever we want at this point. That's what the trustee does. Rights and duties of the beneficiaries. So the owners. The persons and/or entities named in the attachment Exhibit B. Let's go look at Exhibit B. So Exhibit B, right now, this is talking about who has, what their name is, who's the beneficiaries, what is their percentage within this trust. Make sense? Mm-hmm. Okay. So in Exhibit B, it's talking about who is in Exhibit B, including their heirs, assignees, or successors. Hereof are the beneficiaries of this trust. Here's the owners of this trust. And as such shall be entitled to all the earnings, avails, and proceeds of the trust property according to their interest set opposite their respective names. So they're accepting all of the earnings and all that kind of stuff. They're the ones that receive the benefits of this trust. No beneficiary shall have any legal or equitable right, title, or interest as reality in or to any real estate held in trust under this agreement. That means that their names aren't on title anywhere. Their name is basically kept secret in this cause. The trustee will be public, but the beneficiaries will be held private. That's what that means. Or the right to require partition of that real estate, but shall have only the rights as personally set out below, and the death of the beneficiaries shall not terminate this trust or in any manner affect the powers of the trustee. Okay? So the beneficiaries shall not terminate this trust or in any manner affect the powers of the trustee, meaning they're basically not getting in the way of the trustee either. Okay? The interest of the beneficiaries shall consist solely of the following rights respected to the trust property. Okay, so this is the responsibilities and the rights of the beneficiaries. The right to direct the trustee to convey or otherwise deal with the title to the trust property as hereinafter set out. So hey, here's what I want you to do, trustee. This is what I want you to take care of. The right to participate in the management and control of the trust property, meaning that they can manage the trust in the trust property. They can manage it. The right to receive the proceeds and avails from the rental, sale, mortgage, or any disposition of the trust property. So right now, this one's basically saying that they have the right to the rental, the sales, the mortgage, or other disposition of the trust property. So they have the right to receive the proceeds. They can take the money on that side. Now, what the trustee does with that money, it'll talk about that a little bit later, but they have the right to take the money. Okay, so it's giving other instructions to other people saying, yes, the trustee can receive the money. All right, powers and duties of trustee. The trustee, this is an important one. Read this one. The trustee shall not copy or show this agreement to any individual or entity other than the beneficiaries or successor trustees, meaning that someone takes place of the trustee. That means this document is held secret. No one sees this document. It is kept secret. You do not make a copy of this document. This document is a very, very important document. The trustee never shows it to anybody else other than the beneficiaries. Nor shall the trustee reveal the identity of the beneficiaries of the trust property to any individual or entity except by the way of a court order, duly executed by justice or magistrate of a court of competence jurisdiction. What does that mean? That means that the beneficiaries are remaining silent. This trustee keeps these people silent. The only person that is available to even be talked to is only the trustee. The document is not shown to anybody. It's not copied. The only way that the trustee can even describe who these beneficiaries are to anybody, based on this, by law, the trustee has a fiduciary responsibility, meaning it is their requirement that they never expose that person, ever. Doesn't matter if an attorney comes up and says, we are trying to find out who the beneficiaries of this document is. We need to see the document. The trustee's responsibility is a no. Well, we need to know who the beneficiaries of this trust is because the trustee is just the manager. The beneficiary is the owner. So let's say that someone's trying to sue the beneficiaries. The only way that they can even expose who the beneficiaries are, or they have to take the trustee to court first, and then a judge has to say, now you have to expose who the beneficiaries are. Other than that, it is held secret, no matter what. The beneficiaries are kept secret at that point. Okay? Which is really cool. The trustee, as the sole owner of record of the trust property, have the following powers with respect to the trust property as written direction of the beneficiaries. So the beneficiaries is giving them directions. Here's what they are. Here's the following powers in respects towards this trust. To issue notes or bonds and to secure the payments of the same by executing a deed of trust, which is a mortgage, or other security instruments conveying a lien on the whole or any part of the trust property. Meaning, they can issue notes, they can issue bonds. That's what the trust can do, the trustee can do. The trustee can execute deed of trust or a mortgage. They can get mortgages if they want. They can do whatever they want. That's what the trustee is allowed to do on that side. Now, B, the trustee can also to borrow money, giving notes thereof, so they can assume notes. They can borrow money if they want to for the trust, or to assume existing debts related to the property signed by him or her in the capacity as trustee. To invest, did that make sense? Okay. Number C, to invest such part of the capital and profits there from the proceeds of the sale of bonds and notes in such real estate, equities in real estate, and mortgages in real estate in the United States of America. So they can take the rental money and they can reinvest it if they want to. They can put it back into the property if they want to. The trustee is allowed to do that. D, to have, together with, and at the direction of the beneficiaries, the exclusive management and control of the property, as if he were the absolute owner thereof, and the full power to do all things and perform all acts which in his or her judgment are necessary and proper for the protection and preservation of the trust property and the interests of the beneficiaries in the property of the trust, subject to the restrictions, terms, and conditions set forth herein. So basically, the trustee is entrusted to take care of this trust. They need to have management control. So they need to be able to do whatever they want within the trust. They need to have that power, and the beneficiaries are giving them that power to do so. All right? Number E, or letter E, to take possession of the trust property in the event it becomes vacant. So they can take possession of it the moment that it becomes vacant. Something happens. They can do whatever they need to go in and take care of the property. They can. They don't need to get permission to take possession. They can just go ahead and take possession. To purchase any additional real property for the trust at such times and on such terms as may be beneficial to the beneficiary. So if they want to keep adding more properties to this trust, they could do that because it's going to benefit the beneficiaries. And we'll talk about that later. Okay. To rent or lease, it's just giving them the trustee multiple options. If you can get a trust document notarized real easy, then why not have a trust and property owned by every individual trust? You know what I'm saying? Because it's so easy to make. You don't have to manage the trust. You don't have to pay fees for the trust every single time. So, but it's giving you the option to own multiple properties if deemed necessary. To rent or lease the whole or any part of the trust property for long or short terms, but not for terms exceeding the term of the trust then remaining. Makes sense, right? Okay. To repair, alter, tear down, add to, or erect any building or buildings upon land belonging to the trust, to fill, grade, drain, improve, any otherwise develop any land belonging to the trust, to carry on, operate, or manage any building, apartment house, mobile home, lot, or hotel belonging to the trust. They could do any of the repairs, basically. And it's basically blanketing all the terms that it can have. To make, execute, acknowledge, and deliver all deeds, releases, mortgages, leases, contracts, options, agreements, instruments, and any other obligations of whatsoever nature related to the trust property, and generally to have full power to do all things and perform all acts necessary, make the instruments proper and legal, and to do so by a dual appointed attorney in fact. So they can deliver deeds, they can get rid of deeds, they can get rid of leases, they can create leases, they can create contracts, they can create options, they can do whatever they want here. J, to collect notes, rents, obligations, dividends, and other payments that may be due and payable to the trust. To deposit the net proceeds thereof, as well as any other monies from whatsoever source they may be derived in any suitable bank or depository, and to draw the same from time to time for the purposes hereon provided, paying the net proceeds therefrom to the beneficiaries. So the proceeds go to the beneficiaries, but you can deposit the money in the bank accounts too. Okay? To pay all lawful taxes and assessments and the necessary expenses of the trust. To employ such officers, brokers, property managers, engineers, architects, carpenters, contractors, agents, counsel, and such other persons as may seem expedient, to designate their duties and fix their compensation, to fix a reasonable compensation for their own services to the trust as an organizer thereof. So basically they can hire people to take care of stuff. To represent the trust and the beneficiaries. They're representing in the trust, the trustee is representing the trust, and they're also representing the beneficiaries in all suits, legal proceedings relating to the trust property, in any court of law, equity, or before any other bodies or tribunals to begin suit and to prosecute them to final judgments or decree, to compromise claims or suits, and to submit the same to arbitration when in their judgment such courses is necessary or proper. So the trustee can also go to court for the beneficiaries and take care of all that for them. Okay? Trustee, in addition to the other duties herein imposed upon him or her, shall have the obligation to M, to keep a careful and complete record of all the beneficial interest in the trust property with the name and residence of the persons or persons owning such beneficial interest and such other items as may deem of importance or as may be required by the beneficiary. So they got to keep all records that would be beneficial to the beneficiaries. To keep careful and accurate books showing the receipts and disbursements he or she has made on the behalf of the trust and also of the trust property, and to keep books of the trust open to the inspection of the beneficiaries. So as you can see that the trustee has a lot of responsibilities. They can do a lot there, okay? So you got to start understanding that if you're going to be owning property, what position do you want to be in, okay? Now remember, the trustee can be fired by the beneficiaries. So we'll talk about that in a second, but you can see that the responsibilities of the trustee are pretty high. They can do a lot. They can get notes, they can do rents, they can do repairs, they can do all of that type of stuff. So typically, who do you think is going to be the trustee in a lot of these trusts? We are. Okay? Now you can appoint someone else to be the trustee if you want, but understand that they have a lot of duties, and they can tear down the building if they choose necessary. If they want to, legally they can. All right? So you have to trust that person. Nothing in this agreement shall preclude the powers and authorities of a trustee as defined by state law, code of statute, unless such additional powers shall cause this agreement to be constructed as a trust as defined in section of the procedure and administration regulations in the Internal Revenue Code. So they're talking about taxes there. Number 7, compensation of trustee. The beneficiaries jointly and severally agree that the trustee shall receive the sum of $100 per year for his or her services as trustee. Okay? Liability of trustee. The trustee and his or her successors as trustee shall not be required to give a bond, so no need to get a bond, and each trustee shall be liable only for his own acts, and then only as a result of his own gross negligence of bad faith. So if the trustee does anything, the trustee is responsible solely as a trustee for their illegal acts. Removal of the trustee. So here's how you would remove the trustee. The beneficiaries shall have the power to remove a trustee from his office or appoint a successor to succeed him or her. The removal must be in writing, signed by all beneficiaries. Upon 7 days, written notice, the trustee shall deliver all books, records, bank account information, keys, security deposits, leases, and funds in his or her possessions, and execute any documents necessary to convey title and or authority of the trust and the trust property to the successor trustee. Okay? So if you have to fire the trustee as the beneficiary, what happens? All these are instructions. The trust just has a bunch of series of instructions of who does what. Resignation of the trustee. So the trustee decides to quit. Any trustee may resign his or her office within 30 days written notice to the beneficiaries. The beneficiaries shall appoint the trustee named as successor trustee herein, or proceed to elect a new trustee to take the place of the trustee who had resigned, but the resignation shall not take effect until an affidavit signed and acknowledged before a notary public by both the resigning trustee and the new trustee shall have been procured in a form which is acceptable for recording in the registers of deeds, because at the register of deeds office at the courthouse, it's recorded who the trustee is, so it needs to be recorded at the register of deeds of all counties in which properties held under this instrument are situated. If the trustee property is recorded in the name of the trustee itself, which it'll be named in the trust, but if it is in the name of the trustee, the resigning trustee shall also execute a general warranty deed in the proper form and manner for recording the register of deeds in the county in which the property is situate. Said deed and or affidavit need not be recorded unless so requested of the new trustee at the written directions of the beneficiary. In the event a new trustee is not appointed within 60 days after notice of the resignation of the existing trustee is received by the beneficiaries, this agreement shall terminate, and the resigning trustee shall deliver all books, records, bank account information, keys, security deposits, leases, and funds in his or her possession, and execute any documents necessary to convey title to the trust property to the beneficiaries as the interest may appear. Whenever a new trustee shall have been elected or appointed to the office of trustee and shall have assumed the duties of the office, he or she shall succeed to the title of all the properties of the trust, and shall have all the powers and be subject to all the restrictions granted to imposed upon the trustee by this agreement, and every trustee shall have the same powers, rights, interests regarding the trust property, and shall be subject to the same restrictions and duties of the original trustee, except as the same shall have been modified by amendment as herein provided by. So what that's basically saying is that the new trustee has all the responsibility as the old trustee. Death or incapacity of trustee. Upon death, termination, resignation, or physical or mental incapacity of the trustee, the following individuals shall immediately be appointed as successor of the trustee, with the full powers and duties of the former trustee, and then the name of who that person would be. Okay? In the event none of said individuals are then living or unable or unwilling to act as trustee, then a new trustee will be elected and appointed as paragraph 10 herein. Let's look at paragraph 10. That's the resignation of trustee. Okay, so we've already read that. Okay? In the event of the death of any beneficiary, his or her right and interest hereunder, except as otherwise provided, shall pass to his or her executor or administrator, and to his heirs as law. Beneficiaries not bound by trustee. Okay. The trustee is not an agent or partner of, and shall have no power to bind the beneficiaries personally, and in every writing contract he may enter into, reference shall be made to this declaration, and any person or corporation contracting with a trustee, as well as any beneficiary, shall look to the funds and the trust property for payment under such contract, or for the payment of any debt, mortgage, judgment, or decree, or for any money that may otherwise become due or payable, whether by reason or failure of the trustee to perform contract, or for any reason, and neither the trustee nor the beneficiary shall be liable personally thereof. What does that mean? Somebody tell me.
The beneficiary is not responsible for what the trustee does.
Yeah, that's what I think it's saying, yes. Yes, is not bound by the trustee. Yep. Beneficiary is not bound by trustee. Beneficiary is not responsible for the trustee. Okay.
So if the trustee makes a mistake, the beneficiary is not liable legally or obligated legally for a mistake that they make, whether it is done consciously or unconsciously.
Exactly. Dealings with trustee. No party dealing with the trustee in relation to this trust property in any manner whatsoever, and without limiting the foregoing, no party to whom the property or any part of it or any interest in it shall be conveyed, contracted to be sold, leased, or mortgaged by the trustee shall be obliged to see the application of any purchase money, rent, or money borrowed, otherwise advanced on the property, to see the terms of this trust agreement have been complied with, to inquire into the authority, necessity, or expediency of any act of the trustee, or be privileged to inquire into any terms of the trust agreement. So just the dealings with the trustee. Money borrowed, yeah, so in dealings with the trustee. Number 14, recordings of this agreement. So recording it against the courthouse. That's what it's going to talk about next. Neither this agreement nor any summary of the contents hereof shall be placed on record in the county which the trust property is situated, or elsewhere. But if it is so recorded, that recording shall not be considered as notice of the rights of any person under this agreement, derogatory to the title or powers of the trustee. Okay? Basically, you're not recording this document anywhere. Now, the title company typically is the one that will notarize all this stuff, and the title company will also hold these documents, because if you ever have to close on the property, at least they have the documents. So you need to get a good title company that understands trust and understands like what's going on here. All right. So they're the ones that, but they never record it. Nothing is getting recorded onto the title about this trust. Okay.
It says if it is recorded, not be considered as notice of the rights of any person under this agreement referred to the title or power.
That means that if anybody can see
rights. So it's saying if it is recorded, it is showing the rights of the person in the trust, right?
If it's recorded and it comes back to anybody, it's going to come back on the trustee.
Yeah, it's coming back to the trustee.
Not the beneficiary.
Yeah. Term of agreement. This agreement shall be continued for a period of 20 years from the date of its execution. The trustee shall contact all beneficiaries in writing, and again, that can be changed, okay? In writing at least 12 months prior to the time. The trustee shall contact all beneficiaries in writing at least 12 months prior to that time. The trustee shall place the trust property for public sale, pay all debts due and owing with regard to the trust property, and remit the proceeds to the beneficiaries according to the respective interest in the trust. The beneficiaries may choose to renew this agreement for a term of 20 additional years by submitting their intention in writing to the trustee. Okay, so the beneficiaries will write something saying, hey, we like what you're doing, we'll extend it another 20. If any portion of the trust property is in any manner or time period capable of being held in this land trust for a longer period of time than is permitted under the law of the state law governing this agreement, or the vesting of any interest under this land trust could possibly occur after the end of such permitted time period, then, upon the occurrence of the foregoing, the trustee is directed to immediately terminate the trust and to distribute the trust property to the beneficiaries as their respective interest may appear at the time of the termination of the trust. As much as possible, the trustee will maintain the trust property intact and not liquidated, but rather distribute the trust property in kind. Okay, does that make sense?
So if it expires or they have to get rid of it, then they're distributing it to the
beneficiaries. Income tax returns. The trustee shall not be obligated to file any income tax returns with respect to the trust, except as required by law. And the beneficiaries individually shall report and pay their shares of income taxes on the earnings and avails of the trust property, or growing out of the interest under this trust. In the event an information return is required by law, the trustee agrees to execute the same after contacting all the beneficiaries. It is the intention of the parties that this agreement does not create a trust under the definition as set forth in section of the Procedure and Administrative Regulations and Internal Revenue Code, talking about the IRS, okay? So the beneficiaries that are paying their own taxes based on the money that's being made, okay? Assignment of beneficial interest. What is an assignment of beneficial interest? What is that being talked about? Okay, you know how we can assign a contract? The beneficiaries can assign their rights within the trust. Okay? The interest of a beneficiary or any part, that interest may be transferred only by a written assignment, executed in duplicate and delivered to the trustee. If there was more than one beneficiary, the remaining beneficiaries must first approve of said transfer in writing. The remaining beneficiaries shall have a 60-day right of refusal to purchase said interest. So the remaining beneficiaries get to buy 60 days the right of refusal to purchase someone else's interest as the beneficiary. Does that make sense?
Yes.
Unless stated otherwise, any assignment of the beneficial interest hereunder shall also include the power of direction and revocation of this trust agreement. Any beneficiary who assigns his interest in full shall forever waive his right to revoke this trust agreement. Once they've assigned the right as the beneficiary, they're done. Individual liability of trustee. The trustee shall not be required in dealing with the trust property or in otherwise acting under this agreement to enter into any individual contract or other individual obligation whatsoever, nor to make itself individually liable to pay or incur the payments of any damages, attorney's fees, fines, penalties, forfeitures, costs, charges, or other sums of money whatsoever. The trustee shall have no individual liability or obligation whatsoever arising from its ownership as trustee of the legal title of the trust property, or with respect to any act done or contract entered into its indebtedness incurred by it in dealing with the trust property or in otherwise acting under this agreement, except only as far as the trust property and any trust funds in the actual possession of the trustee shall be applicable to the payment or discharge of the liability and obligation. What does this mean?
That the trustees, it's not responsible for anything that's going on with the trust, as far as like if they owe anything on the property or things like that.
No, it's basically saying that there's any kind of lawsuits that are given to the like the beneficiaries can't sue the trustee, stuff like that. Okay, that they're not, that they're paying, the beneficiary is going to pay for the trustees. Like if there's something that happens to the trustee, the beneficiaries are also going to pay for the attorney's fees, the everything else. The beneficiaries are taking on that obligation to take care of the trustee. They're not individually liable or obligated within the trust. Now, the trustee, if the trustee does something illegal, the trustee is. But if something's happening to the trust and they're wanting to sue the trust and they decide to sue the trustee instead of the beneficiaries are going to pay for the attorney's fees and all that. That's what that's saying. Make sense? Yeah. Okay. 19. Reimbursement and indemnification of trustee. If the trustee shall pay or incur any liability to pay any money on account of this trust, or incur any liability to pay any money on account of being made a party to any of the litigation as a result of holding title to the trust property, or otherwise in connection with this trust, the beneficiaries jointly and severally agree that on demand they will pay to the trustee all such payments, see what I'm saying here, made or liabilities incurred by the trustee, together with tis expenses, including reasonable attorney's fees, and that they will identify and hold the trustee harmless of any and all payments made or of liabilities incurred by it for any reason whatsoever as a result to this agreement. Does that make sense? That's what we were just talking about, okay? They're basically connected to each other, just saying it in a different form, in a different fashion. Unanimous direction of beneficiaries. Wherever an act, decision, or direction is required by the beneficiary or beneficiaries, herein said designation shall be deemed to mean all of the beneficiaries acting in unanimous agreement unless a lesser percentage is so specified. Okay? So the beneficiaries vote on certain things too. Okay? Governing law. This agreement and all transactions contemplated hereby shall be governed by, construed, and enforced to accordance with the laws of the state of, and whatever state you're in, the parties herein waive trial by jury and agree to submit to the personal jurisdictions and venue of a court of subject matter jurisdictions located in the county in which property sits. In the event that litigation results from or arise out of this agreement or the performance thereof, the parties agree to reimburse the prevailing party's reasonable attorney's fees, court costs, and any other expenses whether or not taxable by the court as cost, in addition to any other relief in which the prevailing party may be entitled. In such event, no action shall be entered by said court or any court of competent jurisdiction if filed more than 1 year subsequently from the date that the cause of action actually occurred, regardless of whether damages were otherwise as of said calculable. Basically, it's stating that that everything has to go. If there's a lawsuit, the prevailing pays for attorney's fees. In every contract, you should see something that talks about who's paying for attorney's fees. The winning party pays for the attorney's fees. Okay. Binding effect. The terms and conditions of this agreement shall inure to the benefit of and be binding upon any successors, trustee under it, as well as upon the executors, administrators, heirs, assignees, and other successors in interest of the beneficiary. Annual statements. There shall be no annual meeting of the beneficiaries, so there's no need to have meetings, annual meetings. But the trustees shall prepare an annual report of the receipts and disbursements for the fiscal year proceeding, which fiscal year shall coincide with the calendar year, and a copy of the report shall be sent mail to the beneficiaries not later than February 28th of each year. Termination of this agreement. The trust may be terminated on 30 days written notice signed by all beneficiaries and delivered to the trustee. Upon the termination of this agreement, the trustee shall deliver all books, records, bank account information, keys, security deposits, leases, and funds in his/her possession, and executed any document necessary to convey the title of this trust property to the beneficiaries as the interest may appear. Entire agreement. This agreement contains the entire understanding between the parties and may be amended, revoked, or terminated only by written agreement signed by the trustee and all the beneficiaries. And witness two, and then they notarize this, and this document becomes a legal document. The next document is Exhibit A, which is the property that's holding it. Exhibit B is going to be the beneficiaries of that. And then what you have after that is an assignment of beneficial interest in land trust. Let's read that. Undersign blank hereinafter assigners for $10 and any other valuable consideration. So you understand what assignment of beneficial interest is they're giving up the right as the beneficial interest, as their beneficiary rights. Consideration, the sufficient of which is hereby mutually acknowledged, hereby assigns all right, title, and interest in any to the beneficial interest, including but not limited to the power of revocation and the directions in the certain trust agreement dated on blank by and between blank as grantors and blank as trustee of the trust known as blank, a trustee of the trust known as the blank. So they're naming all of the people that are involved in the trust already, that this person is assigning their rights, which owns title to certain property located in blank, which is in the state or in the city of, or the county, to assignees whose address is blank. We hereby affirm and warrant that the beneficial interest assigned herein is 100% of the total beneficial interest, because you can change the percentage as well, but typically it's got to be the 100%. Aforesaid trust, and we have the full power and authority to assign and transfer said interest. We further agree to waive any right to revoke or amend said trust in any way to direct, influence, or control the actions of the trustee. We intend this transfer to be as transfer of the real estate for federal income tax purposes, and we agree to report the same to the Internal Revenue Service. If the real property held in trust is encumbered by a security instrument containing a due on sale provision, which we'll talk about later, it is possible that the assignment could run counter to said security agreement, giving the holder the right to call any underlying debt due and payable, meaning that there's a federal law out there, okay, that you can put if you have a loan on a house. Okay, so if just imagine yourself having you have a house, you have a loan on it. You have a house, you have a loan on it. You have a house, you have a loan on it. I have a house, I have a loan on it. Within that loan that we've written, we've signed that loan, there's an article in that loan that says that if I transfer the title into anybody else's name, that the bank can foreclose. It's called a due on sale process. Okay? However, when I put that title into a trust, there's a federal law out there. It's called the Garn-St. Germain Depository Act of 1982. It's called the Garn-St. Germain Depository Act of 1982. What that federal act, what that federal law is basically saying is that you can transfer the title of your house into a trust, but the beneficiaries have to stay and remain the person that was the owner. So you can appoint a trustee within that trust, but you have to remain the beneficiaries of that trust. Okay? Does that make sense? Yeah. And as long as you're the beneficiaries, you can transfer the title into the trust without tripping the due on sale clause. Does that make sense? Mm-hmm. So what it's talking about right there is it's saying if the real property is held into a trust and is encumbered by a security instrument, meaning like a mortgage or a deed of trust, and containing a due on sale provision, meaning there is a due on sale provision because right now they're assigning their beneficial rights. It is possible that this assignment could run counter to said security agreement, that it could basically violate that loan. Okay? Giving the holder the right to call an underlying debt and payable. So they're just basically agreeing that. They're agreeing that they understand that. Okay? And then they notarize that, and now they've just given up their rights. The beneficiaries have just given their right up as the assignment. Okay? Here's where the trustee gets basically notarizing that they're the trustee. And then this right here is the person. Okay, so this assignment of beneficial rights, you just see their name basically notarizing that they're giving up their rights. This right here is basically saying that they're receiving the beneficial rights now. And this is then notarized. Okay? And then we'll talk about, and then this is a specific power of attorney. The trustee can have specific power of attorney to start dealing with like the loan or something like that, or dealing with the property. Then you can have, and that's again notarized, and then they can deal with certain things within the property as well. Okay? That is a trust. Questions? It's a big one, right?
Yeah.
Sometimes I know that you're going to have a trustee that is also a beneficiary.
Yes.
Okay?
Yes. They can be.
They can be, especially in situations with homes and stuff like that.
Yep.
When you have wills and stuff that are involved. Okay? If you have somebody that is a trustee that is also a beneficiary, say you have 3 beneficiaries.
Okay.
Okay? One of those is a trustee.
Okay.
Now, if 2 of the beneficiaries that are not the trustee do not want that person to be the trustee,
Voting power.
so the power of 2 comes into play.
It depends on the percentage of the ownership of the beneficiaries.
Right.
Okay.
If there's only 2 of you, then you're.
If it exceeds 51%,
Yeah.
Mm-hmm.
then yes. But let's say the trustee.
Mm-hmm.
So let's say the trustee, and let's say that the beneficiaries. This beneficiary has 51%. This one has 19%, and this one has the remaining balance.
Mm-hmm.
Well, then these people can vote, but they can't outvote this beneficiary because this person has 51%.
Right.
So then they can't fire the trustee because they were outvoted.
Okay.
If it's 33, 33, 33 in that example, well, then that would equal 66%. That 66% outvotes this one, and then the trustee can be fired at that point.
Well, yeah. I mean, the reason why I ask is I know sometimes you have deals where you do have partnerships,
Mm-hmm.
and one of the partner is wanting to be appointed as trustee,
Yes,
and sometimes that relationship
goes south
right.
for the winter.
Right.
If it's, let's say, something like that,
It comes down to an actual percentage and power.
yeah.
Period.
So if you understand the beneficial position,
Mm-hmm.
let's say you're in the if you're one of the beneficiaries, you need to understand what voting power you have based on
Right.
percentage of the trust.
Right.
Because that's going to appoint the trustee, that's going to appoint this, it's going to appoint that.
Right.
But if you're a beneficiary, you still have the ability to tell the trustee what you want them to do. Basically, the trustee's just executing everything.
But
So
that's
if
what-
you're going, if you're going to be a part of it, it would be, so you have voting power. It'd be beneficial just to hire in a trustee instead of having one of your beneficiaries be the trustee.
But sometimes there, I promise you, and you'll see it more often than not, there's a beneficiary that is a trustee.
Yeah.
And that's the whole point of the trust. The whole trust, it outlines exactly what you're supposed to do. All it is a guideline. Sometimes you have a trustee that doesn't do what's in the guidelines.
Right.
That's right. Okay.
Tricky.
Anything else on the trust? There's a lot that goes on with that trust. But that trust is as you can see, that document is a very powerful document. There's a lot you can do with that trust. Okay?
Can you name people outside of your bloodline to be a beneficiary of a trust?
Yeah, it could be anybody you want.
Yeah.
Anybody
I
that's
could make you a beneficiary.
Yeah, we can all be beneficiaries of a trust.
Yeah.
We can all be the beneficiary of the trust, 25%, 25%, 25%, 25%, and we can all appoint, as the beneficiaries, we can appoint, since we want to go property, let's go say we want to go buy property here in this area, we can all say, you know what, since you live in Memphis, we'll just let you be the trustee. Okay, we got 25% equaling out to be 100%. So then we all know that Joanne is going to deal all the evictions. She's doing all that. She's doing everything. And then as the trustee, you're going to keep the beneficiaries silent and remain silent. And she takes care of all the property stuff. Right. Okay, the trust owns the property. None of us owns the real estate. We own the trust. Mm-hmm. The real estate is within the trust, and we are just benefiting it based on what's going on in the trust.
Ability to manage.
Yep. So another thing that you can also do, let's say you found yourself a slam dunk deal. Okay? So this is now, once you understand this document, now the opening of creativity is now opening up a lot now. Let's say that you're dealing with an REO property. And in this REO property, they're selling it for $20,000. Selling. Okay? It's worth, let's just say, let's go fair market value. It's worth today $100K. You see the deal, you know it's a slam dunk deal. Okay? Well, but the bank is willing to sell it, but they won't let you assign the contract because you're dealing with realtors' contracts. If you're dealing with REOs, they're not going to let you deal with your own purchase and sales agreement. You have to deal with their purchase and sales agreement. So if you're dealing with like an REO, that means you have to do a double close. You're going to take title to it, and then you're going to close with another purchase and sales agreement with somebody else. Double close. Sometimes the banks will say this: we're selling it, but the person on title has to own it for 90 days before they sell the property. Okay? So they're stopping that double close process is what they're doing. All right? You can't do it. You have to take title and you have to hold it for 90 days before you can close on it. So what you can do is the name on title, the name on the purchase and sales agreement would be a trust. Okay? So the name would be a trust, and then what you can do is you can assign for a fee your beneficial rights. The name on title will still be the name on title for 90 days. But what you've done is you've assigned your beneficial rights within the trust, so it hasn't violated their rule. That doesn't make any sense still, does it?
No, it does, but it's just still staying within your trust.
Yeah. That you assigned your beneficial rights. Make sense?
Yeah, so like if I got it and then I put it in the trust name and I wanted him to have it, I could sign the
beneficial rights over to him for a fee. And then
Yeah.
you have the document to assign the beneficial rights at that point. Hasn't violated it because it's the same title. Now you only do it in circumstances like that. You've got yourself a slam dunk deal. They're sitting there saying that you have to hold title for 90 days. Okay, I'll close in a trust. You're not telling them that you're assigning the beneficial rights because you can close in trusts. So you're going to...
What would be the point of you doing that? Like, what's the benefit of you doing it? Just so you can get money out of immediately, and he would want to hold on to it for 90 days to flip it potentially, or what?
No, let's say that someone... So you're going to wholesale the property, okay? You're the wholesaler here.
Okay.
You found a slam dunk deal. You can wholesale the property, but it's with an REO. It's with a bank. They're not letting you wholesale this property. They don't let you assign the contract.
Okay.
And you have to hold it for 90 days. That means you, the wholesaler, have to come up cash and hold it for 90 days before you can even think about selling the property.
Okay.
All right? Well, what good is that as a wholesaler if we have to wait 90 days to make money?
Okay.
So what we'll do is the purchase and sales agreement, the person that's purchasing this purchase and sales agreement is a trust. It's not a person that's purchasing this purchase and sales agreement.
Okay.
It's a trust.
Okay.
It's a notarized document. You're the beneficiary. You can also be the trustee.
Okay.
Okay? Then what you're doing is at that point is now that you're the beneficiary, you haven't closed on the property yet. You're still under contract, just like you were on a regular purchase and sales agreement.
Okay.
The title is going to be closing with the trust, right?
Yes.
Well, now you can't change the name of who's going to be on title because it's saying a 90-day close. You have to hold title for 90 days.
Okay.
Well, you're going to hold. It's not going to change. It's going to be the trust. What you're doing is you're assigning your beneficial rights, which is the owner of the trust, to somebody else for a fee.
But in order to do that, they have to be inside your trust.
No, you're gonna give them this.
You're giving them the trust. You're creating the trust.
Yeah. You're giving them the whole trust.
You're selling your rights off.
Okay.
You're wholesaling it.
I'm thinking of us all being in the same trust together. I see. Okay, I get it.
No. You're wholesaling. You're wholesaling the property. The bank is wanting to sell it for $20,000. It's worth $100,000. They're saying that you have to hold title. You cannot change the name. They will not let you assign the contract. So means you can't do the assignment of contract. You also can't do a double close. There's no way to do a double close because you have to hold title for 90 days. Okay? The moment you close in this name, that has to stay 90 days. Well, what you're saying is under the purchase and sales agreement, we're just going to put a trust. We're closing in a trust.
I understand that.
I'm making myself the beneficiary of that trust because all I got to do is create it. Okay? At that point, I can assign my beneficial rights for $10,000 in the trust. The trust will own it. Now, whoever the beneficiary is now, they're the ones that own that trust. They can deal with the property. They can deal with whatever they want at that point. And I still haven't violated the 90 days because it's still held in the same title name.
Got it.
Pretty cool, right?